Good morning, Ms. Manning.
SJC-10206, Choy.
Good morning, Mr. Klosky.
Good morning, Chief Justice. Good morning, Justices. Attorney Joseph Krowski for Francis Choy. I'm not only the appellate lawyer because this is an interlocutory, I was also trial counsel. I'm sure you've had enough time to get acquainted with the facts of this case as worked out at trial, but I would suggest that this was a very thin case against Francis Choy.
Well, she did make statements, didn't she, implicating herself?
She made one statement after 3 or 4 hours of
She said she
interrogation.
put gasoline in cups on the steps of the house, didn't she?
That's a very good point, and that's there was no Dia Giambattista tape recording or anything else of that statement. When the police had her, when that statement was made, they had at that time a checklist from Kenneth Choy, which never went into evidence in the trial against Francis Choy. And it was at that time that the police had an idea what Kenneth Choy's participation was in this, if any. And so that they had a scenario, and I suggested during my cross-examination that these were words put into Ms. Choy's mouth, because it never happened in front of any partial witness to Ms. Choy, such as her cousin Nan and her cousin Wynn.
But that was a question of fact, isn't it? The jury doesn't have to believe that.
The
Oh,
sufficiency
I
of the
understand that,
evidence
but
is the question.
the only implication in this whole case was that she said, yeah, I did this, and I did this, and then immediately after that she recanted, Your Honor. She said, no, I didn't, that's a lie. So out of 3.5 hours of interrogation, and this was made at a point where she was handcuffed to a bar at the booking area. That was brought to the jury's attention, but I think after 3.5 or 4 hours, it was pretty de minimis, a pretty de minimis statement made by Ms. Choy.
But we're
Mr.
looking at
Pres-
the sufficiency of the evidence, so, you know, you have to take what she said as something the jury could find.
Well, I understand that, but at this point, I think the question is what the jury was thinking when it was in the jury room based upon the question that was sent out on the second day of deliberation.
Isn't the standard whether the evidence was sufficient at the time the Commonwealth rested its case?
Well, what you had was, in the Commonwealth's brief and what the judge said in his not his findings, in a decision he made later on, was that gasoline was found on Ms. Choy's sweatpants. That's not true. What was found was a trace of vapor that was found in a canister by a state police chemist after the fact. There was never any gasoline found on Ms. Choy's sweatpants. In fact, there was no testing. There were no swatches taken. They could never identify any point at which gasoline could have been located on the pants. It was just a trace vapor consistent with gasoline. It was never testified during the trial that it was gasoline. It was a trace vapor that was brought up through a carbon spectrographic testing.
What's wrong with that evidence? Gasoline evaporates. That's the way that evidence typically comes in arson cases. They find vapors. They don't find the gasoline.
Well, they sent the dog through. They did a complete testing. Now, if you were to believe her statement that she splashed gasoline or she put this gasoline all over the downstairs of the house, you would have had to believe that there would be more than just a vapor on her sweatpants.
Why?
There was nothing found in her room.
What's your basis for saying that?
Well, they had the dog Gayla went through the room. They had forensic people. They had Ms. Stewart, the state trooper, that went through the room. They had all kinds of forensic testing done in the two rooms. The only place there was a hit was down the hallway at the far end of the house. It's not a big house, but at the far end of the house on the driveway was Kenneth Choy's room. And in Kenneth Choy's room, they found an accelerant, they found a lighter, they found a note, a pre-flight checklist, if you will, of what was going to be done by Mr. Choy. It was on a piece of paper with his logo on it from the desk of Kenneth Choy and his fingerprints. That was found in his room. There was nothing found in Ms. Choy's room. In fact, they made a big issue of...
Well, it sounds like you're making a great closing argument, but it doesn't address the issue of the sufficiency of the evidence.
Well, what happened was that all that went to the jury was the vapors a hit on the vapors and a recanted statement. When you boil everything down after 4 days of trial, that's all that went to the jury. And I suggest,
That's enough.
well, that's why we're here, Your Honor, because
you
I'm
also-
asking guidance, because
I assume, Mr. Krusky, that a mistrial was declared also on the murder indictment, is that?
Pardon?
I assume a mistrial was declared also on the murder indictment?
Yes, it was,
Okay.
on everything, because the jury came back deadlocked even after the question was answered, and that implicated the joint venture. The question that was sent out from the jury room two days into deliberations was, do we have to find that Ms. Choy physically lit the fire? Now, the government had intentionally or otherwise inadvertently stayed away from joint venture. There wasn't a molecule of evidence, not a scintilla of evidence of any conversation, any meeting of the minds, any communication between Kenneth Choy and Francis Choy, and what the government was alleged was the planning of this whole scenario. The government, as a matter of fact, objected to my requesting that so-called checklist go before the jury, the judge finding that we didn't know when it was made, which I felt was disingenuous at the time, Your Honors, because it was in Kenneth Choy's handwriting. It was in his room. It was found, I think, near the bureau where the butane, the cigarette lighters, everything else was found, indicating that there might be the utensils or instrumentalities of arson. So there was.
May I ask you, going forward, assuming we don't agree with you, just
Yes.
hypothetically, I understand the brother is likely to testify,
He was a nephew, Your Honor.
the nephew?
He's a cousin of Francis Choy, right?
Nephew of Francis Choy. Francis Choy's father had another family in China.
Okay.
And Kenneth Choy's father had committed suicide in Hong Kong. So he was brought over. He was only living there, I think, about 2.5 years before this incident occurred. Whether he testifies or not,
Testifies with immunity, he might provide information about some type of joint venture, right?
he may. I don't think it's going to be that strong. I suggested to the court, and I suggested during the trial to the court in some sidebar previous to the trial, when I was trying to get that note into evidence, because it was evidence as far as I was concerned, that he was on a frolic of his own, and that there was no evidence that Ms. Choy had anything to do with this fire, except for Kenneth Choy's self-serving statement that was made under pre-DG and Batista conditions.
But you say, I think one of your arguments is that if there is a retrial, that the Commonwealth is limited to a theory of principal liability, correct?
That's correct, Your Honor.
And for authority for that, you cite one Sixth Circuit case,
Yes.
Saylor. Is there anything else that supports that view?
Berry, Fickett, Green.
Those are all cases in which both were tried, and the court found there was insufficient evidence of one, so on retrial you could only try on the other. There was no joint venture that was tried.
Well,
theory.
if there was an acquittal, they couldn't come back and ask the court to present new evidence. In fact, the government is arguing now that Kenneth Choy's testimony would be new evidence, when in fact it is not new evidence. They had the controlling position in putting
Well, it's
Kenneth
not
Choy.
new evidence, but it was unavailable at the time.
I don't believe it was unavailable, Your Honor. Mr. Choy could have been given a different deal. He could have been given immunity. There were a number of options for the government, because they decided to do one thing didn't mean that they didn't have other options. So he was available to them prior to the trial of this case. Now they're going to give him a new deal, which is the same deal that they could have given him before, except now he was acquitted, so they can give him immunity. Whether he testifies or not, I know that he's incarcerated on some drug charges at the present time, I think heroin distribution. So he's in the Plymouth County facility. Whether that has any bearing on whether he will testify at an upcoming trial, should this court not strike that, give me what I'm asking for at this point.
I have a question about something that you said on page 35 of your brief. You say that something exposes the bad faith of the erroneous jury instruction. Are you suggesting that the court purposely gave an incorrect jury instruction?
Yes, I am. And if you turn to,
That's an unusual suggestion.
well, a couple of points here, the judge asked Mr. Bradley for some help in giving him some guidance on some research regarding the phrase "caused to be burned." Now, that became a point of contention. Ms. Choy was only indicted on the first part of the arson statute, not the second part, not the disjunctive part, where the language aids, abets, procures, etc., is in the indictment. She was not indicted in that. When the jury sent that question back, they wanted to know whether she physically, if they had to find she physically lit the fire. Well, there was no evidence, none whatsoever, not a molecule of scintilla, as I said before, of her having a match in her hand or anything else. All of those instrumentalities were down the other end of the hall in Kenneth Choy's room. So when that jury came back, I suggested, well, cause to be burned means you have to do something like, if they're not physically light the fire, but, set off some kind of timing device personally, you have to personally do something.
Couldn't you cause it to be burned? If I asked you to burn a building, wouldn't I cause the building to be burned?
If there was evidence of that, there was no evidence.
No, but so you don't have to physically light
Well,
the
you know,
match or pour the gasoline.
There's not much case law on the word cause to be burned. In fact, the judge says in the colloquy that we had of the discussion, he says, on page, I think it's 14 here, the judge caused the building to be burned or caused the building to be burned. Now, we haven't had time to look it up if there's any case that explains the language. He then goes on to say that or caused the building to be burned on page 7.7-7, or caused the building to be burned. So I don't really know what that means. This is from the judge himself. The judge says, I don't know what it means. Then he goes on to even reiterate and confirm that he doesn't know what cause to be burned means, and there's no case law that we can find, and even since...
So from that, you infer bad faith,
well,
judicial bad faith.
because he sent the jurors back without any guidance. His job is to guide the jurors. You presume that they're laypersons who need to be given guidance. The judge, not knowing himself...
They asked a question, he gave them an answer.
I don't believe, that's why I'm here, Your Honor, because I don't believe that was a good faith answer. I don't know the answer to it. I don't know what cause to be burned mean. I know I have to give guidance to the jury. I'm not going to give them that guidance because I don't know what to do. I'm just going to send them back in to deliberate. And that's not how we do things. Since jurors sat on tree trunks listening to people decide, you just don't send jurors in without...
Clarification, what I understand he did was he answered no, and then he repeated the general instruction about cause to be burned.
And where did he get the no from? If he doesn't know what cause to be burned means himself, it's just arbitrary and capricious. He flipped a coin. I suggest he didn't even flip the coin. No, I suggest he didn't even do that. I believe from looking at the trial, looking at my argument before the judge, that he decided which way it was going to be more deleterious to the defendant and chose that answer because based...
Saying because he didn't agree with you, that was bad faith?
Oh, I think the only logical, if you follow it down its logical path, the only answer that jury should have been given when they asked, based upon the evidence, Your Honor, under certain circumstances, maybe if there's evidence, based upon that evidence, the only answer that I believe that jury should have been given was, yes, you had to show she physically burned it. Because
does the defendant have to be the one who starts the fire physically?
Physically.
That was the question.
Yes.
So unless he said yes, that was bad faith.
Because he sent that jury in to speculate, and a judge with his experience knew better than to send them. Because he says throughout this colloquy that we had that I don't know what it means. If a judge doesn't know what it means, he has a duty. And it was clear, because there was a little bit of contentiousness between the judge and myself regarding what the logical outcome of that would be, although it didn't turn out that way because the jury's still deadlocked. But there was no evidence, and I try to emphasize that and get that across. There is no evidence that she had anything to do with that fire, with physically lighting that fire. If there was some evidence that, and now this is another divergence here. There is the cause to be burned. That was not what the jury asked. They asked physically light the fire.
Does the defendant have to be the
physically
one who
light
starts the fire
So
physically?
this phrase, this dissection of this phrase was something apart from what the jury was asking, cause to be burned. We went on a how many angels on the head of a pin type of argument when the jury wanted to know. They should have been given guidance on that question, and the answer should have been, if you look at the entire transcript, if you look at the entire trial, the answer should have been yes, because there was no evidence that she had anything to do other than that retracted statement that, yes, I put some gasoline here and there. Other than that, there was no evidence that she had a lighter in her hand, that she had anything to do with telling Mr. Choy. So you added a major component of speculation into this argument, because that, and then that gets over to the joint enterprise. There was
And
no
Mr.
joint venture.
Krosky, that gets over to the end of your oral argument.
Pardon? It's the end?
It goes very
I
quickly.
feel like I'm just getting started here. If there are any questions, I'd be more than pleased to answer them.
I think you can rely on your brief.
Thank you.
Thank you. Good morning, Mr. Bradley.
Good morning. May it please the Court, John Bradley for the Commonwealth.
Mr. Bradley, what was the government's theory at trial? That she physically lit the fire, or that she aided and abetted someone else set the fire?
The government's theory at trial, Your Honor, was that Ms. Choy physically lit the fire. And
And was the evidence sufficient to support that?
oh, absolutely.
Okay.
Absolutely. This was a case like most arson cases that rested on circumstantial evidence.
So why wasn't the judge's answer to the question wrong?
Because the government isn't limited, or the jury doesn't necessarily have to decide the case based on the government's theory. Unfortunately, given the limited time window that I had after the jury wrote the question out, I couldn't put my fingertips on the Chico case from the appeals court, which really answers the question and answers this issue, or disposes of this issue on appeal. DeChico is practically on all fours with our factual situation here, and I guess you could say it presages or presupposes this court's recent decision in the Zanetti case, at least as far as arson cases were concerned.
But now you want to retry the case, and you want to try it on a joint venture theory, that essentially she aided and abetted setting the fire.
Perhaps.
She did. Okay.
Perhaps,
Do you
either
think
or.
that's all right?
Yes.
You didn't present any evidence of that at the first trial.
No. But, you know, in terms of fundamental fairness, Your Honor, I would point out to the court that these defendants, the cases were severed over the Commonwealth's objection. And it was the Commonwealth's intention from the get-go to try these defendants together, in which case we would have presented an either-or theory.
But you, at least Mr. Krosky says, you objected to the admission of Mr. Kenneth Choy's notes, which
Right.
would have been relevant to a joint venture theory, correct?
Well, perhaps, but it also would have provided the defendant with a lot of ammunition to solely blame Kenneth Choy for committing this offense on his own. The notes did not mention Francis Choy at all. The notes wouldn't even permit the inference, really, that Francis Choy had anything to do with this. When Kenneth Choy went on to tell the police in a lengthy statement the night of his arrest that he had, in fact, written those notes at her direction because she wanted to make sure that he understood what the plan was.
Do you think that there's anything, the Saylor case that the defendant has cited seemed to me, I know it's a different crime, but seemed to me to suggest, at least that court saying, that if the prosecution doesn't proceed with a particular theory, that's an election, and on a retrial, you don't get to do it again.
But we would have been hard-pressed to proceed with the theory, given the hand we were dealt, Your Honor. That is, the cases were severed. That, in essence,
But
eliminated...
there's a lot of joint venture cases get tried without the joint venture as part of the case.
Well, that's true. But this case was unusual in that I don't believe that based on the evidence we introduced during our case in chief, we would have had a joint venture case that would have been palatable to a jury. However, what I'm saying is, during cross-examination of the witnesses, Mr. Krowski brought out the fact that Kenneth Choy had lighters and lighter fluid in his bedroom, that he had a folded-up towel that he had placed under his door frame, inferentially to prevent smoke from coming in. And what I'm suggesting is that it was Mr. Krowski during the defendant's case that brought Kenneth Choy into the fold here. And because of that, the jury had evidence in front of them that Kenneth Choy could well have been involved in this either on his own or in addition to Francis Choy.
But you didn't argue or proceed on a joint venture theory.
And
No.
the jury weren't asked to
No.
consider that.
No, Your Honor, I firmly believe I don't like to propound different theories to a jury. I think I lose credibility as an advocate in so doing. So I wasn't going to say to the jury, hey, we're arguing that she set the fire, but if you don't buy that, ladies and gentlemen, she was in on it with Kenneth who set the fire.
Did the Commonwealth make it appears that the Commonwealth made the considered decision to try her first and then to try the nephew?
Yes. Yes.
Could you not have made an argument? I mean, I'm not telling you how to do your job, that she set the fire. She may have had the assistance of her nephew, but she's the one who set the fire. I mean, we don't know who set the fire, correct? So, as you started off, it's circumstantial evidence. We don't have a photograph. We don't have a videotape. We don't know who set the fire. So sometimes they are very inconsistent. I wasn't there, but if I was there, I didn't do it. That's a classic, but this is...
Well, that may be a classic, but I don't think it's very effective, Your Honor.
No, that's what I'm saying. That's a classic where it's not effective. But
Right.
here, you can say, the Commonwealth theory is she set the fire. She may have had the assistance of her nephew.
I think that would have weakened our overall position, Your Honor.
Isn't that what you're going to try and do the second go-around?
Perhaps, but the next time around, I have the ability to put Kenneth Choy in the witness stand and lay the whole thing out for the jury.
Is the concern here, I think, is, the Commonwealth gets to try it one way, and then it gets to try it another way, and maybe next time you only do it on joint venture, and you get a hung jury on that, and so the third time you come back and you say, well, now we'll try principal and joint venture. How many times do we let the Commonwealth sort of spin out what its particular...
Well, I don't think that's the fair way to look at it, Your Honor. I think that we play the cards that were dealt. The cases were severed. As a tactical move, I wanted to prevent Mr. Krowski from blaming Kenneth Choy solely the best I could, so I moved to exclude evidence of the note, and I wanted the jury to focus here on Francis Choy, not Kenneth Choy, because she was the one sitting in the defendant's chair. In addition to that, we have Zanetti that has, I think, gone a long way towards clarifying joint venture law that basically says, hey, look, if you have evidence that two or more people may be involved, as long as the defendant had knowledge of the crime and participated in the crime to some degree and shared the intent to commit the crime, then that's sufficient. So I don't see any unfairness, either legally, morally, fundamentally. I don't see unfairness in any way.
Does it matter that this started as a pre-Zanetti case?
It did.
I know it does. I'm asking
No.
you, does that make a difference in
No.
terms of your theory?
No, I don't see how or why it would, Your Honor. The fact of the matter is we're going to try it for the second time post-Zanetti. Before my time is up, I wanted to take the opportunity to ask this court to reconsider its decision from, I believe it was 25 years ago in Commonwealth versus Berry.
Let me just ask you this, Mr. Klosky. If we conclude
Mr.
that
Bradley.
there was... I'm sorry, Mr. Bradley. If we conclude that there was sufficient evidence, we don't need to reach the Berry question, correct?
Correct. I would ask you to reach it anyway.
Well, we try not to.
I'm not sure
I
you'd like us
understand.
to.
Well, worst case scenario is, Your Honor, the status quo is maintained.
No, we try to decide the case. We try to decide the issues that we have to decide.
I understand, Your Honor. I know.
I mean, I don't fault you for raising it because you could have. We may conclude that there wasn't sufficient evidence.
I would ask the court to reconsider Berry based on, I guess, two things. First of all, I would suggest the United States Supreme Court got it right, so to speak, with...
This court decided that we were not going with the United States Supreme Court.
I understand that. But if you look at the logic of the Richardson case,
Which the court looked at.
It did, but that was 25 years ago, Your Honor. And
Well,
I don't think
we
this...
tend to think the precedent lasts more than just 25 years. We still cite to things in the 19th century. Other courts may not follow our lead, but we don't tend to flip precedent that quickly.
Well, times change, and I don't know that this court could have anticipated the volume of business that the Berry case would generate at the time. The fact of the matter is we have a fair number, and I don't have an exact percentage at my fingertips. We have a fair number of mistrials as a result of hung juries these days. And if you look at this case as an example, the delay that this appeal has caused is really almost unconscionable. We have a case now that is over 6 years old, about 6.5 years old. This appeal has taken about 18, 19 months from stem to stern.
That may be the fault of the judicial branch and something that we're trying to address.
But
I don't know how many mistrials there are. I would say that, in my experience, at least in this court, and you come up on a 211-3, there have not been too many mistrials. I can't think of too many recently where there's been an issue of the sufficiency of the evidence taken as an appellate argument. There may have been all kinds of other claims.
I can tell you, Your Honor, I mean, personally, myself, I've had a handful of them. I mean, that's just one prosecutor. You know, they have, under Rule 25, the opportunity to argue sufficiency at the close of the Commonwealth's case, at the close of all the evidence, and then after the case is over, after the jury is unable to decide the case. I would submit that that is a sufficient safeguard to address the concern that a defendant will not be retried based on insufficient evidence.
Brad, can I ask you another question, since we're going off script, so to speak? There was an interview in this case at a police station. It was a 3.5-hour interrogation of a murder suspect. It was the Brockton police station?
Yes.
It wasn't tape recorded. What's with that? Why?
Well, it was, as I recall, Your Honor, it was pre-DG and Batista.
What was the year of the...
2003. As I recall, DG and Batista was
Emphasizing
2004.
your argument of the delay, that the time it takes to
Yes.
proceed in the case.
Yes.
I take it they do tape record
Yes, they do, Your
interviews
Honor.
at the Brockton Police
Yes, yes, they
Department?
do. I mean, it's obviously easier on everybody,
Indeed.
and that was the reason why it wasn't done here. Again, we have the delays are just they don't work to anybody's benefit. You have a defendant who's been in custody the entire time. You have witnesses who disappear, who pass away. All kinds of bad things happen because of delays of this length. And I just don't think when you conduct an overall cost-benefits analysis that this avenue of appeal is appropriate anymore, as it may have been.
Some may think that fairness plays a bigger role than you might in this calculus. I mean, fairness to the defendant.
I understand that, Your Honor. I understand the other side of the argument, but again, I'm suggesting when you conduct an overall cost-benefits analysis, it's not like the defendants are left without a remedy here. They have 3 occasions to argue the sufficiency of the evidence. It's one of those situations, I would suggest, where unusual or bad facts, so to speak, can sometimes make, I don't want to say bad law, but law that might not best serve everybody's best interests. Berry was a baby-killing case. The evidence in that case was unusually weak, so much so that in hindsight it would make you think, well, how come they even brought the case against the defendant?
Well, you might also think, how come going through three opportunities of the defendant to challenge the sufficiency of the evidence, which, as I recall, in the Berry case was done? Correct?
I understand, Your Honor. I certainly understand your point, but I guess what I'm saying is Berry had to have been an anomaly when you compare it to most other cases that this court would see on a 211-3 petition based on the double jeopardy argument.
If I can go back to one earlier point, did you communicate to defense counsel that your sole theory here was that Ms. Choy lit the match? Was that ever communicated to defense counsel as the sole theory on which you were?
You know, Your Honor, I can't answer that with 100% certainty. I believe it was, but I can't say for sure.
And when you say it was, you mean because there was a bill of particulars that was sought, or that you communicated in some correspondence?
I think it was brought up at a pretrial conference. And, you know, again, given the severance and given the Commonwealth's position to attempt to exclude the note, I think it was pretty clear how we were going.
Is that what you argued to the jury?
That she was the one who lit the match?
Yeah.
Yes.
Notwithstanding that, you have no problem with the response to the jury's question.
That's right. That's right. And frankly, Your Honor, in my heart of hearts, I do believe she was the one who lit the match today. That's what I think happened, and that's what I argued, but the jury should still be able to find that she may not have lit the match, but was nevertheless involved.
And the evidence as to the towel, that came in through you, or it came in through defense counsel?
Through defense counsel.
Thank you, Mr. Bradley. Mr. Bradley, I have one request. It may just be my copy, but my copy of the brief doesn't have the table of authority, so if you would just give some amended copies of the brief, that would be helpful.
Absolutely, Your Honor.
Thank you very much.